actually reminded me, she had mentioned this earlier, but she has interesting perspective because she has been a literary
Thanks for the great question. Chaz, nice to meet you.
as well.
I've heard a lot about you. So.
Also taps into both, from both of those backgrounds.
Thank you.
Please.
Feel free to leave or doze off, or if you are sleeping, stand up, stretch. It might be more useful if I did talk about gendered judges and how that matters in sex discrimination cases, because it's probably more useful. But as Pat says, I'm a visiting professor here. I left full-time legal academia some years ago to pursue sort of a joint career in the publishing industry and legal academia, and one way to put my interests together is actually to write about some of the laws relating to the publishing industry. And we have seen a lot of legal stuff in the publishing industry, surprisingly, in the last little while. Just for Debbie, who just came in, we switched.
Oh,
We switched. So I am not talking about gender discrimination. So I'm writing a book at the moment, basically for authors. So it's a legal handbook for authors to help them understand just basic legal information: copyright, fair use, contracts with agents, contracts with editors, what if you're self-publishing, defamation, privacy, all of that good stuff. There are books for authors out there that are written in very legalistic terms, and then there are craft books on writing that have a page saying, here's what a copyright is. And there's really nothing that explains this to authors. And unless you do pro bono work, or I do know some sole practitioners who take on some authors as just smaller clients and help with contracts, there's very little legal help available to those folks. But while writing the book, I've come across a lot of issues that I wanted to explore in more detail just as a lawyer, as a law professor, because I just thought they had interesting legal dimensions. And this one, it's kind of fun, and the cases are kind of funny, but they do involve real money. They do involve people who are trying to make their living either out of writing or out of representing people who write. And I think someone who's been a lawyer or a law professor and has studied rules of professional ethics can sort of look at the author-agent relationship with a kind of ethical eye, and thinking about sort of legal practice, the lawyer-client relationship, and obviously it's a very different relationship. But when you think about things like contractual duties and fiduciary duties and stuff like that, what can we kind of draw into the author-agent relationship? Because this is a relationship where neither party typically understands anything about the law. There are some agents who are lawyers, and one of the cases in my paper, and I've written this up as a paper, does involve a lawyer who's also an agent. But most agents don't know much about the law. Most authors know nothing about the law. And so there's these cases that talk about contract duties and tort duties and fiduciary duties, and it's like, the parties to the case are just, they don't know what's going on, they don't understand what their obligations are. So I thought this was interesting to look at. And as of about 2 weeks ago, as Pat mentioned, I became a literary agent. So I can now look at it from both sides of the table, because I'm an author and I have published and I have an agent, and I've signed a contract with an agent who is at a different agency. And she repped my book on legal stuff for authors, which is coming out with University of California Press. But I'm also an agent, and she reps adult nonfiction, I rep children's literature. And so I send contracts out, and I just signed my first client today. She actually just got the contract, so I'm very excited by that. She's a disability advocate, and she writes great children's stories about inclusion and diversity and she's just a terrific person. So I know that agents are very excited about their clients' work, and they want the relationship to work, and it doesn't always work. And what's interesting to me, and I think why I wrote this paper, is that last year, 2017, 2018, there just seemed to be a lot of what I would call bad agent cases. There was a lot of stuff in the news in many different countries, notably this one, but also Australia and Britain, where agents and authors were suing each other about various aspects of their relationship. And it was fairly clear that the parties either didn't understand their contractual relationships or they did understand them and they were trying to pretend they didn't understand them. So really this is all about contract law, it's all about, it's legal stories about people who tell stories for a living. And I gathered together a bunch of these recent cases and issues just to talk about them and talk about what lessons we can learn from them as a legal matter and as a matter of people who deal with these usually fairly basic, fairly simple contracts. An author-agent contract is, you know, typically, you know, the one I signed with my agent is 2 pages long. I mean, it has pretty small font. They're usually no more than 5 pages. They have fairly standard clauses. There are industry standards on the financial stuff. You know, they basically say things like, well, here's the percentage your agent gets for a domestic sale, here's the percentage they get if they hire a sub-agent for a foreign sale or a subsidiary sale. A big one that came up in the Morden case that I'm going to talk about is typically what happens, and this is logical if you think about it, an agent does get a perpetual commission for a deal that that agent has brokered. So if the author then moves to another agent or another agency, but I've brokered the first deal, I keep getting commission on that deal. I own that deal. My agency owns that deal while the book is in publication. Once it goes out of print, the rights revert and whatever. That one can be problematic. People don't understand that one well. There can be issues about choice of forum, choice of law clauses, but a lot of these are governed by New York state law because a lot of the agents and publishers are in New York. My agency is actually weirdly based in Minnesota, so our contract is governed by Minnesota law. Generally, that doesn't make a great difference in practice. So they're fairly standard, fairly simple contracts. And they're fairly clear. And people generally, if you bothered to think about it, you would understand the contractual nature of the relationship. But what's happened when these cases have gone to court is fiduciary arguments, obviously, because you have a principal-agent relationship. I mean, this is your classic principal-agent. The agent is, you know, your agent is acting on behalf of you as a principal to sell your work. You engage them to do that. So it's not a fiduciary principal-agent scenario because they're called an agent. It's because that's what it is. It's an agency. And authors often don't feel that they're the principal. They often feel that they have no bargaining power and that the agent calls all the shots and whatever. And that's, you know, that's just a matter of unfamiliarity with the industry and the area, and that happens with lots of different kinds of principal-agent type relationships. Happens with lawyers. You know, your clients don't know as much as you know about the law as a lawyer. So that's not unusual. The question I'm asking in this paper is whether the fiduciary characterisation helps or matters or makes a difference, given that these contracts, these situations are already kind of ridiculously complex because the parties don't understand. The law's pretty simple, but the parties don't understand it. And then once you start arguing about fiduciary relationships on top of contractual and tortious duties, it gets very, very expensive for everyone. So really the question I looked at when I looked through these cases that came up recently is fiduciary arguments were raised, but the courts didn't really do anything with them. At the end of the day, all the decisions are really based on contract law and tort law, which is interesting to me because I'm not at all advocating saying that a classic agent is not a fiduciary as a legal scholarly matter. But what I am saying is when you litigate, you know, when you think about these kinds of cases, sometimes spending a lot of argumentation, ink, bringing in a lot of witnesses, etc., to talk about fiduciary relationships is a waste of money if you can deal with something as a contract matter. And I was just going to go through, and I don't need to talk for a tremendously long amount of time because it's late in the day, and I don't have any pretty slides because I couldn't think of what to put on pretty slides other than pictures of all the characters and their books, which I could have done, but I was lazy and I didn't. But what I did give you in the materials, if you look at the Dropbox materials that Pat Chu sent around, or had sent around, I gave you some press clippings about a lot of these cases, like the Publishers Weekly report on what happened at Donadio and Olsen, what happened in the Kate Morden situation, what happened in the Danielle Fox situation. So you get the nice gossipy, punchy version of all of this, and if you want to talk scholarly stuff, email me and I'll send you a copy of my draft article. But let me tell you about some of the stuff that happened. And I'm going to preface it by saying my conclusion at the end of the day, after I talk in a very gossipy way about these cases, is what I just said. You know, I'm not convinced that fiduciary relationships make a huge difference in a legal analysis of most author-agent relationships. So they probably are best left as your kind of alternate argument in litigation, not kind of your main argument, because you don't need to go there. I think one of the big problems, or not problems, but one of the big reasons why you don't really need to rely on fiduciary relationships is because your paradigm fiduciary situations where you're arguing fiduciary duties, I mean, think about corporate directors, investment advisors, that kind of situation. Those are people who are agents of the company or the trust or whatever it happens to be, who must owe these fiduciary duties because they often, like think of a corporate director, they often have so many different interests. That's why they're directors. They know a lot about business, they know a lot about transactions, they have a lot of fingers in a lot of pies. So you must ensure that that person doesn't breach a duty of loyalty and discloses any potential conflict, because their interest could very well conflict with the entity to which they owe a fiduciary duty. Agents and authors aren't really like that, because what typically happens with an agent is your agent only makes money when you do. Agents work on pure commission basis, which means that the financial interests are almost always closely aligned. It's almost always the case that what's in the best interest of the client will be in the best interest of the agent, in which case talking about sort of duties of loyalty and duties to avoid conflicts of interest don't come up in most cases. They come up in rare situations, but not in most cases. They're not very helpful just because of that structure. The other problem, and this is a problem with contract, tort and fiduciary relationships, and it's a problem you have in a lot of areas of law where you can't establish a clear harm with dollar signs on it, is, well, even if there's a breach of any of these duties, what's the harm? There's one case I'll tell you about, the Morden case, where it was actually pretty easy to quantify the harm. But in most cases, if you're saying, well, my agent gave me bad developmental editing advice, or my agent sent to these 10 publishers and didn't send to this 11th publisher who might have made an offer if they'd known about it. My agent told me to lead with my second manuscript and not my first manuscript, and I think the first one was better. Like stuff like, how would you ever quantify whether that would have sold? In fact, in the Kate Morden case, a lot of evidence, and she's a best-selling, Kate Morden, The Lake House, The Shifting Fog. She has a new book out now. She's Australian, but she lives in the UK. Her books are everywhere. She's made millions and millions of dollars. Even in that case, there was an argument about, well, even a really best-selling author, there's no guarantee that their next book will sell as well as their last, or that the previous thing that they didn't sell would have sold as well as... Publishing is so subjective. It's very hard to quantify damages. So that rings true for fiduciary, contract and tort duties. It's very hard to establish damages anyway. So let's talk gossip. Let's talk about these cases. There's a whole bunch of them I discuss in the paper, and a bunch of them that I gave you in the Dropbox materials. But the big one I keep referring to is Kate Morden. The final decision was handed down in the New South Wales Supreme Court in December, so that was now 2 months ago. It's an Australian case. It mirrors a lot of American, or a handful of American cases that I will also mention. But the reason I start with it is because that case could be a textbook. The court decision could be a textbook on the sort of author-agent relationship, contract law, tort law, fiduciary law. There's principles of evidence in there. Basically, and it's almost a 200-page, like it's a 150-page decision. For those of you who did not go to law school in Australia, and that would be most of you, I would think, we're a little different to the US. We have these really nice, short, sweet, easily drafted statutes. Our statutes are really easy to read. Our court decisions are like hundreds of pages long. So where our law is very tricky is when someone says, oh, you better go and read the case about that because you don't want to read those cases. They're just long. It was something that was really weird to me. Like I came to the US 20 years ago and I'm like, wow, the Supreme Court cases are so short because in Australia they're just hundreds of pages long. This is a basic sort of the equivalent of a district court case. Single judge, it's 150 pages long. So it's extremely good, and if you have time to read it, it's got some great information in there, but that's why I will tell you about it and you don't have to go and read it, because the equivalent American case that I'll talk about, the Fern Michaels case, is 10 pages, and it covers all the same issues. Actually, the facts are more complex in that case. So what happens in Morden, in a nutshell, is she's this big deal author. She had this little, mom and pop shop kind of agent in Australia, Selma Anthony. So Selma Anthony is just, at the time, I don't know what her office looks now, but she's just a single, sole agent working out of her house, representing a lot of small authors that no one's ever heard of. A lot of them are academic authors, so no one's ever heard of them. Like, we're academics here, no one reads our stuff. So, if you want to write the great American novel, send it to me and I'll look at it. But yeah, exactly. So, she's not very sophisticated, is the point. She doesn't have written contracts with her clients, so it's actually not even clear who are her clients sometimes. Like, someone will send her a manuscript, she'll say, I like it. I don't do written contracts. She might send something out. Like, if you look at the evidence, she has this just very sort of laissez-faire. And then if she sells something, she reminds the person, what they spoke about on the phone, which was that she gets her 15% cut and they agree to that and that's fine, whatever. That's what happened. That's how Kate Morden was discovered. Anthony brokered a number of deals for Morden. In Australia with the leading Australian publisher, Allen and Unwin. And she sold foreign rights. She basically licensed foreign rights to Allen and Unwin because they had a big overseas presence, so they did the foreign deals on Morden's first 6 books. Subsequently, Morden moved to the UK. She got to know her UK publishers better. She found out that this really wasn't a very standard arrangement, that what usually happens is that an agent holds back foreign rights from the first sales, from the original sales, because you can make more money then if you sell them independently to other publishers. What happens when you have the first publisher selling them, A, they're in control of the deals, so you lose your control over the foreign deal. And B, they will take a commission on top of the agent's commission, and then they will engage a foreign agent who will also take a commission. So you end up with 3 layers of commission on the royalties. Whereas if you did it yourself through your own original agent, there would be 2 commissions. There would be her 15% and the foreign agent that sold the book in the UK, the foreign agent who sold the book in Africa. Turkey is a big one at the moment. So Morden discovered she was paying triple commission. She was paying 3 commissions, 3 layers of commission, and she should have been paying 2. Or she wished she had been told that she could have been paying 2 levels of commission. So she, her counterclaim is, you gave me bad advice on the foreign deals. But it's actually Anthony who's suing Morden. Anthony is saying, you owe me money because you had your UK publisher cut me out of perpetual commission when you sign with your new agent in the UK. And as I mentioned, perpetual commission is fairly common in agent contracts, but they didn't have a written contract. So the court said you don't get perpetual commission because you didn't negotiate it. On the evidence, we accept that it's trade custom. We look at all this evidence on trade custom, but it wasn't in your contract because you didn't talk about it. And you were very unsophisticated and you didn't know what you were talking about, and you're stuck with what you actually did talk about on the telephone. So Anthony loses her claim for the perpetual commissions. The evidence is really weird because she doesn't even believe, I mean, the judge is trying to help her. You see all the whole cross-examination and everything laid out in the judgment. The judge is trying to help her explain her contract. And Anthony's belief is she doesn't have an oral contract with Morden. She believes her contract with Morden comes from the publishing contract with Allen and Unwin, because there's that notice clause in the publishing contract that says all notices go through Zella Anthony as my agent. You know, that's just your agency clause. That's just saying send notices to Morden via her agent, Zella Anthony. Anthony believed that was her contract, and that's why she believed she couldn't be cut out of the commissions, because she thought she was a party to the publishing contract, and she wasn't. She's a party to an agency contract. The agency contract was silent on perpetual commissions. She had no rights under the publishing contract. And agents don't. The publishing contract is between the publisher and the author, and agents don't understand that. Like, that's the problem with this area. No one understands what they're talking about. So at the end of the day, the court says, well, you don't get your perpetual commission, you're not a party to the publishing contract, and you do owe damages for your negligent advice on the foreign commissions. And this, as I say, is the one case where you can quantify damages, because there's 3 commissions. You just take out the middle level of commission, right? You just say, okay, what should have happened, assuming she'd made these sales, she's a bestseller, she probably wouldn't have done better than she... So it's not a question that she's lost foreign sales. It's a question that she's paid too much commission. You can simply take out Allen and Unwin's commission and make Anthony pay that, reimburse that to Morden. So that's the one case I've seen where you can actually quantify damages and say, okay, that's what the agent owes. But with respect to why, whether that was contract, tort or fiduciary, after 150 pages of judgment, Judge Ward basically says, it's not fiduciary. I'm just not going to go there. There's been all these arguments advanced about, well, she breached her duty of loyalty because she, the agent, had a friend at Allen and Unwin and she wanted to keep her friend happy while, having this nice deal with Morden. No, the Judge Ward says, no, that's just business practice. All 3 of them are benefiting from the contracts. The publisher, the agent and the author, their interests are aligned. That's not a breach of loyalty by Anthony to Morden. There's arguments about, well, it's a conflict of interest because Anthony saved herself some time by not having to separately negotiate the foreign contracts. She just did this one contract and then she didn't have to do any more work and she still got her 15% commission. And the court said, no, it's not really a breach of fiduciary duty. It's not really a problem with conflict with her not having to exercise the work she would have otherwise, because there's just not enough evidence about how do you figure out how many phone calls she would have made. She might have made 1 phone call to a foreign publisher the same as she made 1 phone call to Allen and Unwin. You just don't know that. So what happened was that the court says, well, fiduciary duties don't really help us, but she was clearly negligent as a matter of just your due care and skill duty under contract law, regardless of due care and skill under fiduciary law. Under contract law, you have to perform adequately, and she didn't. She should have told Morden about how to negotiate foreign sales. Even if that was not correct, tortious, negligent business advice, there'd be a tort remedy. So the court in Australia says, we don't need fiduciary duties here. We can use contract and tort. And you could say at this point, well, that's just Australia. They have funny accents, as you can see, funny accent. Their laws are weird. Their judges write 150-page decisions when they could write 10 and go to the beach and surf. So I don't know why they don't. But there are American judgments that are very similar, and I don't think I gave you in the bits and pieces I put in Dropbox, but I do talk about it in the article, just because it was a year earlier, so I wanted to bring it up. This Fern Michaels case, now even if you know who Fern Michaels is, you're not going to admit it in this room, because she's a trashy romance author whose books are at the checkout stand at Giant Eagle. They've been there for about 60 years. She's 80 and 80-something, and she's been writing for decades, and she's made millions and billions of dollars from these little, see, Kevin knows. But the point is she's very sophisticated in business matters. She knows what she's doing. She knows what a contract is. Like, unlike Morden, who at least at the beginning of her career could have argued, well, I didn't know, I was just this housewife, I was having a baby, took some time off, wrote this thing, and then it became a bestseller. And that was Kate Morden's story. Fern Michaels, whose real name I really can't pronounce, it's Kuskier or something. It's Mary Kuskier. I've never been able to pronounce it. So this is a very similar case where her agent sues her for basically cutting him out of a deal that he negotiated. So this isn't about ongoing commissions, this is about just him getting paid at all, because she's tried to cut him out of the deal. And she counterclaims, again, like Anthony and Morden says, well, you breached your contractual tort, fiduciary, and legal professional duties, because he was also a lawyer as well as her agent. So in that case, he had been her lawyer for years, and she knew how he charged for legal services on an hourly basis, as is typical for transactional lawyers. She expressed dissatisfaction with her agent when she was chatting with him. He said, well, I can do that. You know, you've got pretty established relationships with your publishers. I'll be your agent, and I'll be your lawyer. I'll do both. And they negotiated an 11% commission, which is less than standard. Right, so there was obviously some negotiation there. Like, the court looked at that and said, well, that's not the standard commission, so obviously they were negotiating and they knew what they were doing. So she then decides that she actually sues people a lot. Like, if you Google her, she's constantly suing publishers and agents, and she's probably made more money suing people than writing books. So she claims, well, what she does, and this just shows how kind of business savvy she is. So she's not your typical author. She sets up a new company, purports to cancel the contract, the publishing contract Friedman had negotiated for her, then enters into the same contract via the new company rather than via herself as the author, in order to kind of make it look like a different transaction, and to sort of cut him out of the deal he had negotiated. And he sues her, and he says, I negotiated that deal, and she's trying to cut me out of my commission. And the court actually, he succeeds in this case. The legal analysis is very, very similar to Morden and Anthony, because what happens is the court goes through sort of contract duties and tort duties, and fiduciary duties. And actually the thing that they're most concerned about is legal ethics. They're most concerned that he didn't keep his lawyer business separate from his agent business, that he'd send joint accounts and stuff like that. So that was the biggest concern. It actually, I mean, I guess it has elements of fiduciary duty because it's a lawyer's ethical duty, but it was discussed under the New York Code of Practice. It wasn't discussed under agency fiduciary general principles. But the court says, well, none of that matters, because these were two arm's length bargaining people who knew what they were doing, and whatever duty there was, she ratified what he did. She understood. She understood what was going on. She consented to it, and as a matter of principal agency law, under the Restatement on Agency and the laws that follow it, you can do that. A principal, I mean, this happens all the time in the corporate area, right? Corporate directors can engage in transactions that would be in breach of their fiduciary duties if the other directors consent. Occasionally, if the shareholders consent, there might be provisions for that in your bylaws or whatever. So at the end of the day, the court really says, well, there is fiduciary stuff going on, but it doesn't matter because of contract anyway. And so you could look at that two ways. You can say what I just said, the fiduciary stuff doesn't matter because the contract overrides it, or you can say, well, the fiduciary stuff is there and it was ratified by contract. Either way, you could just go straight to the contract and say, okay, you contractually agreed this, there was no procedural or substantive unfairness in the contract, it's a valid contract. So he loses there, he wins there for the same reasons that Anthony loses, a contractual analysis, effectively. And this is a case where you can quantify the damage, because this is the case where you could say, like Selwa, Anthony and Kate Morden, you could say, yeah, here's the amount he should have got, and he didn't get it. I did want to mention one more case. I know the last speaker went over, so I don't know how much time I can yammer. Okay, I'll talk about one more case. There's a few other situations that didn't end up in court that I could mention, but I do want to talk about the Levin v. Grecian case, which was a 2013 case in the US District Court for the Northern District of Illinois, this slightly earlier case, because by comparison, this case talks a little bit more about not the money side, about what agents actually do day to day, because as I'm learning very, very quickly, I kind of knew this already because I interned for 3 years with an agent, so I knew what I was in for. We do spend most of our time actually reading and developmentally editing manuscripts. We do not spend most of our time making deals. If you look at the amount of hours you put into a particular client, the bulk of it, 90+% of it is developmental editing of the manuscript, and a small percentage of it is then sending out to editors and negotiating deals. So you really earn that 15% because you're not paid for any of the editing. That's because of changes in the professions, the publishing profession and the agenting profession, since the 90s probably. So if you went back to the 70s and the 80s, the publishers did most of that developmental editing. A lot of people got published unagented. It wasn't nearly as important to have an agent then as it is now, unless you want to self-publish, which is a whole other thing I can talk about the legal aspects of. But that's changed a lot because I think digital technology impacted publishing. More people were writing, there were more manuscripts, it was easier to send them. There was a lot of consolidation in the publishing industries. There are less editors on deck, even when you work with a publishing house, they do use freelance editors. Now, any of us who do academic books, there's a lot of freelance editors in academic publishing where there used to be in-house editors in the publishing houses. So there've been a lot of changes in the publishing industry that have necessitated agents taking on more of the developmental editing role, and that is, a lot of what agents do. When you look at your slush pile, you're not picking out the perfect manuscript and sending it to an editor. You're picking out a manuscript that you think has the most promise and working on often 4 or 5 drafts before it goes out, because the publishers expect it to be that good. They don't, and they edit, they still edit, but they want it at a higher standard than they did in the 1970s and the 1980s. So Levin versus Grecian is a case that looked a little bit more at those day-to-day things that authors expect agents to do. So editing work, communicating, going back and forth on the state of the manuscript and other questions. I mean, agents are now very much career planners, much like entertainment agents have always been for the talent. I always think of the movie Jerry Maguire, or Sidney Pollack's character in Tootsie, how they're trying to handle these incredibly difficult clients. They're trying to guide them through these careers and find opportunities and field offers. think literary agents are becoming a bit more like that, you know, a bit more like the career planning people for the authors. And that's what this case was about, that there was this guy whose work wasn't selling, who was contacting his agent all the time with ideas and thoughts, and the agent wasn't very responsive, and the agent hadn't really sold anything for a number of years. And then there was a new project that the agent really liked, brought on a co-agent, and it sold immediately. It was a graphic novel. It was pretty successful. And so then the author sues the original agent and says, well, you breached all these duties to me, largely fiduciary duties, you know, just for your failure to communicate, to take interest, to give me good editing advice. And this goes very much to the fiduciary, the agent fiduciary duty, if you think back to the restatement of agency, you know, to be communicative. I mean, there is a duty to be communicative with your principal and to keep them informed, but you usually think of that in terms of transactions. You know, you usually think of that in the corporate directors context, or in the realtors, or, you know, lawyers. It's more, oh, I need to tell my client that this settlement offer came in. I need to tell the company of this business opportunity. You know, it's that kind of thing. It's not, I need to tell my client what I think of his, you know, 5-page single-spaced email about the plot ideas for his latest whatever. Because, you know, even if you have just a dozen clients, many agents have more than that, you can't do that within 5 minutes. You have all these clients and they're sending you all their thoughts. My agent is hysterical. She's not hysterical. I'm very proud and very pleased to have the agent that I have for my non-fiction, but she's been in the game a long time. You know, her dad, I think, was the original editor of Bantam Books. She interned with them. She's been for decades in the publishing industry. She was the agent who discovered Barack Obama as an author. She agented Dreams from My Father and, you know, got his book out. She's very savvy. She likes to make deals, and that's what she likes to do. And she does not want to be hearing from me about this great idea I had at 2 a.m. for this picture book series on whatever. And I have, you know, over the year or two we've been working together, I have learned what not to send to Jane at, you know, 6 in the morning. She'll respond to me, but, you know, she doesn't want to be bothered with this stuff. So there are lots of different models of an author-agent relationship, and there are some agents who are very motherly and who are, you know, I know many agents in Kidlit who do that. The problem is, how do you put a legal duty to that? Because that's so personal and it's so subjective. And so here you have a case where really the piece of evidence from this case that really gets me every time, because I just don't know why the court was even talking about, and I'm just quoting here, the court took particular note of the fact that out of 781 emails exchanged between the author and the agent, only 270 of them were sent by the agent, suggesting to the court a lopsided ratio of communication. Now, what the heck does that mean? It's like, that client could have been doing what crazy authors do at 2 in the morning and saying, what about this idea? What about this idea? What about this idea? Or that client could have just been sending drafts of chapters, in which case there would have been, I mean, there's lots of reasons. The client might have sent 500 emails and the agent would have only sent 200. You can't quantify that with any kind of legal duty. So because that case was a summary judgment, it was a dismissal of a summary judgment, you can't get a lot of law out of it. You can really only look at the facts. But it was interesting to note 2 things, and I think they'll probably be the 2 points I'll end on because I've yammered long enough. But the 2 things I would note, one is that the court was inclined to say it did appear that the agent had, they didn't hold on this decisively, they just made the comment in the summary judgment context. It did appear to the court that the agent had maybe breached an implied contractual duty to use all due care and skill. So not the fiduciary duty, but there's this implied contractual duty, as we know, to sort of perform your contract appropriately. And so the court had the impression that, in fact, this agent who hadn't responded to 500 emails maybe didn't exercise all due care and skill as a contractual matter, not as a fiduciary matter, as a contractual matter. But then went to the damages point, then said, But in any case, how would you ever establish damages? How would you ever establish what your damage was because he hadn't answered all your emails, or because he had failed to sell your first 3 manuscripts and sold the fourth? It might be that the first 3 weren't saleable. I mean, yes, the court thought it was telling that he needed a co-agent to sell the fourth, but that still didn't say anything about whether the first 3 manuscripts would have sold. I could talk a lot more about bad agents because there were a bunch of cases, some of which you have in Dropbox, that were reported in Publishers Weekly of all sorts of agent malfeasance. And actually there was a sexual harassment one that happened a week or 2 ago, which is, you know, that's not even fiduciary duty, that's sexual harassment, and this guy was fired from his agency. He was basically cyber stalking his clients, which was horrible. But I think, you know, I'll end where I began by simply saying my title of my paper is a little misleading because, yes, of course, agents are fiduciaries. We all know that. It's principal-agent relationship, fiduciary. But at the end of the day, I don't think it really means anything. I don't think it matters a lot, because the fact is the only time it really does seem to matter that you have a fiduciary classification, and the court even then said contract, is the duty to kind of communicate effectively, which A, is also a contractual duty, so you don't really need the fiduciary duty, and B, you can't really quantify the damages or the harms anyway. So at the end of the day, this is kind of a sort of negative outcome paper, because instead of saying, wow, agents are fiduciaries and here's all these exciting things we could learn from that, I'm basically saying, you know, the baseline message is people need to understand their contracts. These are small, simple contracts. People need to read and understand them. People need to seek legal advice if they don't understand their contract. I know it's difficult to afford sometimes. Agents need to understand their contracts. Everyone needs to understand their contracts. I'm a transactional lawyer, you can tell. And I think that's what we need. I think we just need a greater sort of awareness of getting stuff in writing and signing it. So that's really where I ended up at the end of this talk in this paper. I don't know how much time there is left, but
Oh, I think we have time for a few questions.
Okay.
Oh, thank you.
Yes.
Fiduciary duty is very important in the investment field.
Yes. Yep.
You mentioned that at the very beginning. Assuming there's no contract, like in your first case, Morden.
There is a contract. There's a contract.
There's no oral contract, but let's. I'm concerned with the fiduciary duty. When I do a securities case and I'm going into federal court with it, their first defense is I'm a bank, or like UBS came back and said, no, we're a bank, we don't owe a fiduciary
Yep.
duty. But I need to show that there's a fiduciary duty before I can get the damages. Because they're like, you know, we don't owe you a fiduciary duty, so you won't get damages.
Like broker-dealers.
It's like
Yeah.
broker-dealers, banks, so you have to establish that fiduciary duty before you can claim and collect damages.
Yeah.
So why is that not the case in?
Because there's always a contract. I mean, I would say even if Anthony had sent out the manuscript without specifically telling Morden she was doing it, she's still acting with apparent authority as an agent, and she's acting as under an implied contract.
Yeah, but that's different, but the fiduciary duty
Yeah.
is in the law.
No, I do get
Applies
that.
to the collection of damages.
I guess what I'm saying is I find it very hard to imagine a case where someone would ever send out a manuscript on someone else's behalf without there being an understanding between them, even if it's just oral.
No, yeah, I get that part,
Yeah.
but if there is no written contract,
Right.
it's just a couple of words, yeah, I'll do this for you, I'll take 15%.
Right.
There's your contract. It's
Yeah.
a basic, simple
Yeah,
contract.
yeah.
But I can't, let's say they do this and they screw it all up,
Yeah.
and you go to the court, and let's say it's reverse, Norton sues her.
Yeah.
Okay. But there's no written contract.
Right.
You have to rely on the law saying that agent, she acted as an agent, she therefore had a fiduciary duty, and that is the only way to
No,
get damages.
agree with you, and that was where I started out. But then when I looked at what all the courts are saying, they're all going out of their way to find a way not to do that. Like, to me, that would be the logical thing to do. But because the Morden Anthony situation, it would seem, yes, just impose a fiduciary.
To me, that would be the easiest way to
Right.
resolve the case.
And I
Except in terms of a written contract.
right, and the only reason, you know, because I can't answer why the courts are doing this, but what I'm suspecting is because they're dealing with really unsophisticated parties and they really want to keep the law simple. But that's not a legal reason. That's me, like, I can and you can make that argument about investment advisors too, because like how many clients read any of the stuff or
I can
know?
tell you, none.
Right, so I am totally legally where you are, but that's why I wrote this, because I thought, wow, this is really interesting, because all these courts aren't doing this. Yeah,
Curious as to why the
yeah,
courts would
and
rely
none of them
on
say why.
the law
Right,
and the duty that's established under the.
and that's the question I want to answer, and I can't answer it. Yeah, yeah.
I just have a tangential trivial question.
Oh, trivia.
not a legal question.
Yes, we love
Is
trivia.
it really true that when a book is represented by an agent, that they actually get more royalties for the author?
No.
Because I didn't have an agent, I'm just making sure.
No, you're talking academic press versus commercial trade press.
Either way though, I mean, you can't even get your book to a commercial press without an agent.
The only, okay, so what happened with mine, for example, the first offer on the advance was, I think, what they would have offered an unagented author. My agent went in and got them to raise it so that I ended up getting the same amount of money, but she got extra. So I don't think the author would ever get extra. But I can totally see that if an agent negotiates, the agent will be saying, well, now the author will get what you were prepared to pay anyway. I don't think authors get, I haven't seen that, but I don't know. Did anyone else have, yeah?
I think it's kind of an interesting question. I mean, as a general premise, I think about that fiduciary obligation as being a duty beyond
The regular,
I presume, I mean, I guess the place where you would see maybe a case is that somehow an agent cuts a deal with Bantam because
Yeah.
they want
yeah,
a continuing relationship for another client. And they think that by giving them this good new stuff with this new author, I'm going to get a repeat business on this solid, dependable person. And in some way, I negotiate a deal for the new client that isn't as good as if, because I was trying to use it
Yeah. I would say two
where there's
things.
a cross dealing, even though.
Now, I'll say two quick things in response to that. One of them is that something like that came up in Levin v. Grecian, where he wanted producer money if the thing ever sold to this company in which he had an interest. And the court said, no, that's fine, because you've disclosed it and it's fine, but it was the same property. I think the cross-benefit issue doesn't come up in practice much because of the nature of the publishing industry at the moment and the entertainment industry. There's so much movement. The people aren't in the same chairs for long enough for that to matter. Like our database at our industry, we change it weekly as who's where and who's at what imprint. You develop your relationships with the editors, and the editors like the people who sell them good stuff. But it doesn't seem to be, I can see it happening more with producers, you know, in LA. So like if you were dealing with Disney Hyperion or something. But I just think that paradigm that you would expect to see, you actually don't see that much. Because there's so little money in it, the margins are so tiny, people are really under the gun to just get something that will sell. You're never going to buy something that's subpar as a cross deal because you like this guy. You're just not. You're just going to say no because you're accountable then to the next person up the chain. I haven't seen it, doesn't mean it doesn't happen. But I take the point. But again, people put a lot of this stuff in their contracts too now, so yeah, I don't know. I don't know the exact answer, but I have not seen it happen. And I've been a groupie in this field for many, many years. Like that's why I know these cases. I'm like a junkie for any case that has anything to do with this stuff. And yeah, it just, there's a heck of a lot of movement in all of these industries. The relationships, I mean, you may have your Spielberg and your whoever he likes buying options from, but in books, you know, it's just not so much. Pat?
Thank you.
Thank you, everyone, for accommodating me.